Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and today I will talk about the case of Commissioner Income Tax Chennai versus Mohammed Meeran Shahul Hameed, wherein the Hon'ble Supreme Court interpreted Section 263 subsection 2 of the Income Tax Act 1961 that provides for the period of limitation for revising an order of assessment. The facts of the case are not necessary for our purposes, and hence the same are not being discussed. Briefly speaking, Section 263 subsection 1 of the Income Tax Act deals with revision of orders that are prejudicial to revenue. It provides that the concerned authority may interfere with an order passed by the assessing officer if the same is prejudicial to the interests of the revenue. However, Section 263 subsection 2 puts an embargo upon the exercise of powers under Section 263 subsection 1 by stating that no order shall be made under subsection 1 after the expiry of 2 years from the end of the financial year in which the order sought to be revised was passed. Thus, a period of limitation of 2 years has been provided in Section 263 subsection 2 for exercising the powers under Section 263 subsection 1. This 2 years period is to be calculated from the end of the financial year in which the impugned order was passed. Generally, a financial year commences from 1st of April and ends on 31st of March of every year. Hence, if an order was passed on 1st of October 2020, then the financial year of 2020-21 would end on 31st of March 2021, and 2 years from 31st of March 2021 would be 31st of March 2023. Hence, for an order dated 1st of October 2020, the period of limitation as per Section 263 subsection 2 would expire on 31st of March 2023. But in the present case, a question arose that whether the relevant date for the purposes of considering the period of limitation under Section 263 subsection 2 would be the date on which the order passed under Section 263 subsection 1 is received by the SSE or not. Here, the court looked into the relevance of the date of service of the impugned order on the SSE under Section 263 subsection 2. In order to understand this conundrum, let us go through the pertinent observations by the court. Firstly, the court observed that receipt of the order passed under Section 263 by the SSE has no relevance for the purposes of counting the period of limitation. Secondly, the court noted that no order under Section 263 of the Act shall be made after the expiry of 2 years from the end of the financial year in which the order sought to be revised was passed. Therefore, the word used is made and not the order received by the SSE. Thirdly, the court further clarified that once it is established that the order under Section 263 was made or passed within the period of 2 years from the end of the financial year in which the order sought to be revised was passed, such an order cannot be said to be beyond the period of limitation prescribed under Section 263 subsection 2 of the Act. Fourthly, according to the court, the date on which the order under Section 263 has been received by the SSE is not relevant for the purposes of calculating or considering the period of limitation provided under Section 263 subsection 2 of the Act. And lastly, the court also emphasized that if it is accepted that the date of receipt of the impugned order under Section 263 subsection 1 is relevant for computing the period of limitation, then in that case, it will be violating the provision of Section 263 subsection 2 of the Act and to add something which is not there in the section. As observed herein above, the word used is made and not the receipt of the order. As per the cardinal principle of law, the provision of the statute is to be read as it is, and nothing is to be added or taken away from the provision of the statute. Thus, it was held that date of receipt of order is not to be taken into account while computing the period of limitation under Section 263 of the Income Tax Act. That was all about the case. So what are my concluding remarks? I concur with the reasoning of the Supreme Court that words of the statute are to be given paramount importance and the same are to be interpreted without adding or subtracting anything in it. In any case, taxation laws are to be interpreted strictly, keeping in mind their true purpose, that is, fulfilling the interests of the revenue. Hence, I hope you enjoyed listening to the show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.